So before I start, I'll just give you a little bit of information about my background. As I said, I'm Senior Litigation Counsel with Harsco Corporation. Harsco is a global business operating in the steel sector and in the rail sector predominantly. I came to law as a second career. I was working in business, doing fairly well or reasonably well, and decided for better or worse that I'd try my hand at being a lawyer. I was called to the bar at Lincoln's Inn, just around the corner, so I qualified as a barrister first. I then cross-qualified as a solicitor. I worked at the city firm Norton Rose Fulbright for a number of years. And whilst I was there, I was given the opportunity of an in-house secondment at BP within their legal team. I found that really interesting. I really enjoyed being able to follow matters through from beginning to the very end, and you don't often get that opportunity when you're working in private practice. So when my secondment came to an end, I decided I would join or go in-house full-time, and I've been with Harsco ever since. So in trying to give you some insight into how to manage your client and avoid or deal with conflicts, we're going to start off by looking very briefly at our professional obligations. We all have them, depending on your jurisdiction, that they'll vary slightly, but we all have them. I'm going to touch on compliance because I feel that when you're dealing with conflicts, that's always there, particularly where in-house lawyers are concerned. I'm going to look at how you can, the importance of empathy, how important it is to you in your role, and also how you can build trust with your clients. And then I'm going to go into a couple of case studies, which hopefully you'll find interesting. They are real-life case studies. One of the important things I think for in-house lawyers is having that relationship. When you're in private practice, your client comes to you when he's got a problem and he accepts that he needs a lawyer. When you're working in-house, your internal clients may not come to you, well, they'll come to you at that stage, certainly, but they'll know about the problem a lot longer than, or a lot before you will. They'll know about issues that are coming up. They're dealing with their customers. They're entering into a bad contract. You'll be sitting in your office. Ideally, you want them to call you in as early as possible so you can help them. So how do you get them to call us in, first of all? Well, let's just look briefly at our professional obligations. These are from the Solicitor's Code of Conduct. There's just an example of some of them. They guide what we do on a daily basis. Most of these are fairly straightforward and self-explanatory. The first one, we should uphold the rule of law. Well, that seems fairly obvious for a lawyer. Our first duty is to the court. We should act with integrity. Again, I think that's hopefully fairly obvious. David and I were talking about a certain politician before, a little while ago, and we were talking about his integrity. So it's quite interesting how prominent some people can be, and you can look at them on the outset. They look very, very good, honest hard-working people, but they may actually lack the integrity. We shouldn't allow our independence to be compromised. When you're working in-house, you can come under a lot of pressure from your clients. Your clients are working under time pressures, various other pressures, and they'll put pressure on you to try and bend you, if you like, away from where from giving the advice you think you should be giving. Acting in the best interest of your client. Well, that's quite an interesting one, because what are your client's best interests? Does your client even know? But also, who is your client? And I'll go on to that in a little bit more detail. That's an interesting point. And then, of course, we've got this obligation to deal with regulators in an open way. And that could conflict with privilege. If you've got some sort of regulatory investigation going on, you've also got certain documents and advice protected by privilege. So on the one hand, you've got an obligation to deal with them in an open way, but how far how open do you be? So having noted what our professional obligations are, and these will vary from jurisdiction to jurisdiction, and you'll all hopefully be aware of what your obligations are. How do we build that trust and how do we build that relationship? Well, to my mind, the most important thing is empathy. Now, empathy is understanding your client. What are the aims of your employer? What are the aims of your client? Well, firstly, profit. It's a business. They're there to make money. They're not there just to provide jobs for lawyers. So their main aim, or one of their main aims, is profit. That's important. And as I said, Harsco's in the steel industry, so we're well aware at the moment all the problems that are going on in that particular sector. How do they build this profit? Well, sales, obviously. They'll be looking for growth. They want the business to grow year on year. They want to remain competitive, and that brings its own pressures. but also the share price. You know, if it's a PLC or whatever, the share price is going to be important. And coming into that is reputational issues. I won't go into too much detail because I know David's going to be talking about that, but where your client is concerned about the reputation of the business, that's normally a good sign because they will come to you at that point. Sometimes it can be a little bit too late, but at least they will look to you for advice and some help. So we know what the aims are for the company, for the business or for your client. How do they achieve these aims? Most organisations will have a sales team of one type or another. Now, these are quite unique individuals. Certainly since I've been working in-house, I've gained a lot of insight into these guys. Despite the fact that I had a background in business, so I'd worked alongside salespeople for most of my working life, I still, working in-house as a lawyer, you still really gain a lot, big, important insight into these guys' minds, how they think. What are their motivations? Well, the chances are they may well have sales targets. If they achieve these targets, they may well get a bonus. They'll be looking for recognition. They're normally competitive people by nature. They want to be the best at what the job they're doing. Now, they all those bring issues because, if they take a short-term view, they're go-getters, they're driven people, they're in a fast-moving environment. They might want to enter into this particular contract, or they might want to breach a contract, or they might want to do something that you wouldn't advise is a good idea, but for them it could be a short-term gain. So they look for perhaps the next 6 months maybe, whereas your job as a lawyer could be looking into the next 6 years. So they take short-term view, you've got to take the longer-term view, but you've got to understand what drives them. That's really important. That you don't want them to see you as someone who's there to stop them from getting sales. If you get yourself into that situation, to be honest, you're not going to be doing the best you can at your job. Certainly, we've had a situation within our own business where the sales team were entering into contracts, which in the year they entered into them, they were good contracts. But as the steel price has dropped, we're now finding that in some of these contracts we could be operating at a loss. So, just take that longer term view. So once you've got yourself into a position where you can understand what drives your clients, the next stage, to my mind, is to try and build trust within those clients. And so how do we do that? Well, there's some bullet points there. You need confidence in your own abilities. Your employers employed you as an in-house lawyer. You've probably been well trained. You've got plenty of experience. Your employers employed you for a reason. You're not going to be an idiot. So just have belief in yourself. Be consistent with your advice. If you tell them, just don't flip-flop, don't change your mind along the way. Be calm and rational. I put that there as quite interesting because your clients, quite often, they won't be. I've had clients screaming down at the phone down me, we've got to get this done, we've got to get it done today. And, you've got to be open with them, say, well, look, that's fine, I understand your position, I understand the pressures you're under, but we just can't do that at the moment. And tell them why. Be correct. Well, okay, my notes here say, well, don't lie, but that's probably wrong. I think just if you're unsure of something, tell them you need to go back and you need to look into it. I think as any lawyer, well, I've come across a lot of lawyers who tend to bluff their way along. I've come across some partners at very large law firms who earn a very good, decent living out of bluffing. They're just very good in front of the client. Oh, yes, we can do this. Yes, it's the law on this is such and such, such and such. I've had arguments with an ex-boss where I've shown the legislation and said, look, this is what it says in the statute. No, that's wrong. You've misinterpreted it. So just don't get yourself into that position. And probably the most important one to me is don't just regurgitate the law. And this is one for private practice lawyers as well. We instruct lawyers around the globe. And you'll be surprised at a number of times we'll ask a local counsel for advice and they just come back and this is what the law is, almost verbatim. And that's just, well, if that was what I wanted, I could have gone to the internet or gone to a library and got that myself. That isn't what I want. I want to know how you interpret the law. I'm not particularly interested in what the law is. I want to know what advice I need to give my client. One of the things, when I had my appraisal before Christmas, and we do this 360 appraisal, so I have to give my boss the names of a number of people I've been working with within the business. And he goes out to them and he gets feedback. And one of the things I'm quite pleased with was one of my clients came back and said, we really like working with David. He doesn't tell us what the law is. Sometimes he doesn't even mention the law. He just gives us very commercially focused advice. And that I see is my job. I go and look at what the law is, I identify what the legal position is, and I identify the way forward for the business. They don't care what the law is. They're not interested. They haven't got the time to read it for a start. So as already mentioned, you should interpret the law and advise on the way forwards. Managing deadlines. I was telling David, I've been off on holiday for this. It's my 25th wedding anniversary on Tuesday, so I was trying to spend some time with my wife and family. On Monday, I thought, hopefully have a nice quiet day, clear the decks, and of course, as it always does, everything kicked off. All sorts of problems coming in. I was on the phone until 11 o'clock Monday evening, still working, just trying to get things sorted, and I've been on the phone every day since. Just tell your clients, you've got different clients in different parts of the business. They don't know that you're really busy working for another part of the business. So just be open to, I'm dealing with X, Y, and Z. I'll get round to it as soon as I can, but realistically, it's probably going to be Thursday. And I've got a call this afternoon with a guy who really wanted a call on Tuesday. But he understood the position I was in. But also managing expectations. This is quite an interesting one because we've got various litigation going on around the globe. Some of them are ex-employees that are suing us for unfair dismissal, where they've been dismissed for, I won't go into detail, but they've been dismissed for in circumstances where they were very, very rightly dismissed. There was all sorts of wrongdoings going on. We've got a situation in one jurisdiction now where we've been trying to get the police to look into the background of this fairly senior ex-employee. He's got a lot of assets that outstrip his income. You know, his assets, the more what he gained during the period he was working for us, he couldn't have gained just through what he was being paid by us. And we're trying to get the police to look into this because we feel it's evidence as to the wrongdoings. We learned fairly recently that the police are probably not really going to go into it. It's not that, in the particular jurisdiction, it's not that big an issue for them. They're not really bothered. And there's also various allegations going on about this guy knows the prosecutors, he knows the local police and all the rest of it. And we've got the US Embassy have been involved, everybody's been involved. But anyway, the point of me telling you this is we're getting to a position where we may have to settle with this guy rather than go through the courts with his unfair dismissal claim, because if we go through with the police having dropped the criminal element, chances are we may well lose. So at some point in the not too distant future, I'm going to have to get on the telephone to my client, fairly senior guy in the business, a Yorkshireman. Anybody who knows the country or knows anything about Yorkshiremen, they can be fairly blunt and abrupt and to the point. And I'm going to have to suggest to him that, look, we really need to settle this one. And I think wherever you are in the world, you're probably going to hear him scream down the phone because he's going to go ballistic. But that's the best way forward. So what I'm trying to do now is sort of set the seed. So we sort of say to him, look, the police investigation isn't going too well. This is looking a bit rocky. And gradually over a period of time, I'll sort of manage his expectations so we get to the point where when I do drop the bombshell, hopefully I still sort of come out of it alive. But we'll see. So I said we'll touch on compliance, and I will just touch on it. One thing there, who is your client? Is it the salesman or is it the company? I was at an interview a while ago and I was asked this question because they were talking about compliance issues. They gave me this scenario where there was a sale going on in some particular jurisdiction and it was quite obviously a bribe. But if the bribe wasn't made, the salesman would lose the order. And so they said to me, well, who is your client? And my response was, well, it's not necessarily the salesman. Although he's the one getting the business, you're trying to help him. But if he's going to pay a bribe, that's obviously going to be to the detriment of the company. So, ultimately your employer, the company, is your client. You've got to advise the individuals, but you need to keep in the back of your mind just who your client is. Now, again, if there is something nefarious going on, if there are bribes or whatever going to be paid, that can bring them to reputational issues, which I say I won't go into. And of course, you've got the Foreign Corrupt Practices Act and also the Briberies Act. Shows on the slide there, Polypack and Azul and Deer, the reputational issues that came out of that. And I think the gentleman, he's out of prison now, but I think he sentenced something like 10 years. So we've touched on fairly briefly, almost sort of flown through this. I'm going to give you a couple of case studies now, and I'm going to ask for some interaction. I just want to get your view on how you think we should go. So this is I won't tell you the jurisdiction for reasons which will become apparent, but there was a road traffic accident. It wasn't in the UK, I won't say any more than that. There was a lorry being driven by our employee. It was one of the company's vehicles. A motorcyclist unfortunately pulled out in front of him, and it was a fatal accident. The police carried out their investigation. We had local counsel appointed just to protect our employee. I was on a conference call with local counsel and our local management, and local counsel said to me, well, the police have concluded their investigation. We think it's going to be a fairly good outcome. All we need to do now is make the reward payment. Well, sorry, what do you mean by the reward payment? He said, well, the police, they'll be expecting a reward for having done a good job with their investigation. And this is our local lawyers were telling me this. So I said, okay, well, what happens if we don't make the payment? And they said, well, they'll go back, they'll reinvestigate, and they might come out with different conclusions. And that will take time, and your legal fees or our legal fees will exclude, be higher than what it was a fairly low amount, the payment. But local council's advice to me was you should make this payment. Now, the driver's obviously concerned. He's the guy that potentially could be prosecuted, and God knows what the outcome of that could be. Now, what would you do in this scenario? Anybody want to give me some feedback?
I think it depends on the institution. If it's an American entity, I'll probably advise against it, and if it's equally a UK entity because of the FCP and the UK bribery hat. But if it's a Nigerian company where I come from, I'll probably say pay.
Okay. But it is a US entity, because I work for a US entity. So
well, it's grievous. It's a serious situation for any American company to pay a public officer for doing the work. And it could come out later to bite them. So even though I'm a Nigerian counsel, I would say don't do it.
Yeah. Okay. Anybody got any different views?
Yeah, I fully agree that if it's an American company, it's a no-go situation. So call the embassy.
Okay.
Well, it depends on the size of the payment and whether it could be considered de minimis or a facilitation payment under the FCPA. Those are really the only ways you could possibly have an exception and be allowed to make the payment under the FCPA.
Thank you. Okay, well,
Just to add maybe, I think it's maybe possible under the FCPA, but I think it's impossible under the UK bribery.
correct. Okay, well, because I don't want to take up too much time, but yeah, you're right. Under the Briberies Act, we couldn't make the payment. Didn't matter how much it was. I think it worked out to about $5,000 US. So I told our local council, we can't make the payment. We're not making the payment. If we did make the payment, I could be arrested. I could be struck off. It's against our company's code of conduct, so I could get fired. We cannot make the payment. So I said to them, go to the police, tell them we're definitely not making the payment. Tell them we've noted that they've asked for the payment, and tell them we'll be in touch with the US Embassy in the next few days. Within about a week, the police came back and the conclusion was still the same. There was no issues for the driver. So it's important, because I could have got into a real mess there. If I'd made the payment, that could have caused all sorts of issues for all sorts of people, especially me. I'll give you another one. I probably won't ask questions because I don't want to take up too much time, but this is another case study which, again, is a real situation. We had a major dispute with a customer in an overseas jurisdiction because we delivered some equipment late. The equipment was being delivered from the US, so we've got two entities. We've got a UK entity and a US entity. The UK entity has loaned some equipment to the customer to try and help the US entity, but the UK entity needs that equipment back for a tender it's got in the UK. If it doesn't get the equipment back within a fairly short period of time, they could lose the business in the UK. But if they bring the equipment back earlier than the US entity can provide the new equipment, they're going to hack off the customer abroad, and that's going to materially, impede their growth plans for that jurisdiction. So I'm on a call again. I've got US colleague, UK colleague. I work for the corporate entity. Both got different views. Real problem because there's some heated conversations going on. Now, the only thing I could do there was I tried to find a solution for both entities, which was impossible. We tried discussing then some sort of compromise. We'd leave the equipment there for 6 months and then bring it back. That didn't work. So the only thing I could do then was escalate it to the head of the business, and he took the decision. The head of the business is in the US. The head of the business decided to follow what the US wanted, which hacked off the UK, but there we are. So that sort of gives you an overview of the sort of some of the issues that we can come up with, and those of you that are working in-house probably come across these fairly often. So just give you a summary of what we've gone through, and then hopefully you'll be looking like Charlie, who's on the right, the one with his tongue out. So you'll be nice, happy, understand the way forward, and hopefully you won't have got yourself in a mess like Dudley, who had just rolled in a load of wet ash. So thank you very much for your time.